Sweden has finished its COVID inquiry. Ours has barely begun. If it were done when 'tis done, 'twere well it were done quickly. But today there's been the synthetic row about WhatsApp messages between the Cabinet Office and the COVID inquiry. Now it seems the government will be taking its own inquiry to court. As you know, I'm often willing to criticise the government when it's wrong, but on this occasion, it's right. If they get this enormous quantity of information, the chairman of the inquiry, Lady Hallett, will drown in trivia, and her report will not be completed in time for the next pandemic. Lady Hallett has asked for every WhatsApp message, but the government won't provide that which is unambiguously irrelevant. And the government's right. Read the Act. Section 21 of the 2005 Inquiries Act says the chairman of the inquiry may by notice require a person, quote, to produce any documents in his custody or under his control that relate to the matter in question at the inquiry. The chairman is not entitled to go on a general fishing expedition, which wouldn't be in the interests of the inquiry, which needs to be moved in a timely manner. Indeed, a timely manner is one of the terms of reference of the inquiry itself that the chairman is obliged to follow. What we need to know from the inquiry is straightforward. Were the lockdowns necessary and proportionate? Why was the vaccine rollout so successful? There's a good model for inquiries. We've done it before. Andrew Tyree did an inquiry into the banking crisis. He did it as a parliamentary inquiry. He even had the Archbishop of Canterbury on the panel. And it was done within a couple of years, costing a few millions of pounds rather than into the hundreds of millions that this inquiry is costing. And its suggestions were quickly put into place to make our financial systems more secure. We need to make sure that this inquiry is done in a timely and efficient way and look at other countries. But we also need to move away from the obsession with COVID, because malicious and officious prosecutions of technical lockdown breaches are still going on in secret courts, which is not good for British justice. It emerged today that a key worker, Mr. Kevin Brown, who worked as a technician keeping the power on during the pandemic, has been fined over £2,000 for a trivial lockdown breach that took place 2 years ago, and more cases are still currently going through our courts. But there's a backlog in the courts. They're years behind with serious cases. Why are they faffing round with trivial lockdown COVID-related cases? We need a swift inquiry, swift answers, and we need to be thinking about the future, not endlessly harking on about the past. But of course, as always, I want to know what you think. Mailmog@gbnews.com.